Thank you so much. My name is Courtney Buchan. I'm the corporate trainer for GRS Community Management. I'm also a licensed CAM and board member myself. So a little bit about GRS. We're a mid-sized management company based out of Lake Worth, Florida. We just opened an office in Jupiter, Florida, but we service all of our great state. We have communities on the West Coast, East Coast, North, South, you name it. So if you're happy with your management company, great, we love that. But if you are not happy with your management company and you're looking for new management services, take a look at our website at grsmgt.com to get more information about what we provide board members. We have over 100 managers on staff and a lot of support staff as well. You can also follow us on our socials, so LinkedIn, Facebook, that's where we're always posting. We posted today's webinar. We have other webinars that we host, a lot with Kaye Bender Rembaum, a big shout out to them. They do the best on providing board education and community association manager education across all facets. So this is not the first class I've done with them. Specifically, I've done several with Kerstin. She's wonderful. She's over at their Tampa office. She's the managing firm member at the Tampa office. I think I got that title correct. So she works out over there. Kaye Bender Rembaum has a lot of resources. Definitely check out their website at kbrlegal.com. They have a whole calendar of events that they do. So big thank you. Today's class is going to be a great class, covenant enforcement. That's such a hot topic for most communities, or should be. So I know Kerstin's going to do a great job doing the presentation today. With that all being said, I'm going to shoot it over to Kerstin to get us started. So thank you for having me.
Thanks, Courtney. Always fun doing these webinars with Courtney.
Yes.
As Courtney mentioned, I am one of the attorneys with Kaye Bender Rembaum. I am located on the West Coast in Tampa, but we do have other locations throughout the state. Our main office is in South Florida, Pompano Beach area, and then we do have an office in Palm Beach Gardens as well as in the Orlando area. For those of you who are not familiar with the firm, KBR is an exclusive community association law firm. So that means that we exclusively represent community associations, condominium, HOAs, and cooperatives. I've been practicing law about, I guess, going on 18 years, and I've been with the firm since 2010. All right, so today we're going to cover covenant enforcement, and let me go ahead and share the slides.
And while Kerstin's sharing the slides, I'm just going to quickly mention, so you don't have to ask, you don't have to take copious notes here. You don't have to go crazy. There will be a link to download and save these slides after you fill out the evaluation that we explained a little bit earlier. So I'll go over that again at the end when Kerstin is finished with the class. Back to you, my friend.
Great, thanks, Jeff. All right, so covenant enforcement. A little bio about myself. All right. So the association is charged with the responsibility of uniformly enforcing the governing documents and the covenants, restrictions, and rules and regulations set forth therein. Now, the failure of the association to enforce covenants, restrictions, and rules and regulations in a timely manner may result in waiver or forfeiture of enforcement rights. So let's break down this statement. So first of all, what are your governing documents? Your governing documents will consist of 3 primary documents, and this applies both for HOAs and condominiums. The supreme document is going to be your declaration of condominium if you're in a condominium association, or your declaration of covenants or protective covenants if you are in an HOA. Then you're going to have your articles of incorporation, and then after that, you'll have bylaws. So your declaration, whether of condominium or of covenants, is going to be the document that contains your covenants and restrictions, what you can and cannot do. Are you allowed to have pets? Are you allowed to lease in the community? So forth and so on. The articles of incorporation and your bylaws will essentially set out the corporate structure of your association. As you may be aware, the association is an entity, not-for-profit corporation that is governed under Chapter 617 of the Florida statute. And so when the developer created your association in your community, one of the documents that the developer had to file was the Articles of Incorporation, which are filed with the Division of Corporation in Tallahassee. So that creates your association. And the articles will contain things like, who qualifies as a member of the association, who qualifies as a member of the board, who are your officers, and then the bylaws are really more of an extension of your articles of incorporation. So it'll have a little bit more detail, more meat to it. It'll include things like how you run your elections, what happens if a board resigns, etc. So those are your governing documents. Your use restrictions and covenants really should be contained within the declaration. They should not be contained within the bylaws or amendments to the bylaws. Okay, so when we're talking about covenant enforcement, we're talking about enforcement of the restrictions in your declaration, as well as rules and regulations. Now, your rules and regulations are not considered part of your governing documents. They are simply what they are, just rules and regulations that either clarify or expand on the covenants. Now, for enforcement, right? The second statement here is that if you don't enforce uniformly, the violation may result in a waiver or forfeiture of enforcement rights. So what does that mean? Well, first of all, when you enforce any rule or covenant or restriction, the first thing I would look at is, make sure that the restriction or the rule is clear, right? That there are no ambiguities. I see over and over, boards adopting rules or boards, presenting these amendments to the owners that, have either ambiguities or vagueness. And so it becomes difficult to enforce if the language is not, precise. So when either working on amendments to your declaration or on rules, strongly encourage you to get your legal counsel involved in the drafting stage. And I can tell you from experience, it is way more cost effective and efficient if you tell me what it is that you want drafted and have me drafted, as opposed to the board trying to draft and then have me trying to decipher and figure out what it is, that what your intent is with the rule. So get your legal counsel involved at the front end of covenant enforcement, which really begins with drafting. And then the second thing is, when it comes time to enforcement, you want to make sure that you uniformly enforce your covenants and rules. So what does uniformly mean? It means you enforce your rules and covenants against all your owners and residents, okay? Not selectively, right? So if you enforce a pet restriction against, Johnny Smith, you got to enforce it against, Sally. What happens is that if you don't enforce your covenants uniformly, okay, then if you didn't enforce the pet restriction against Johnny, and then you try to enforce the pet restriction against Sally, Sally can then raise defenses, okay? And in particular, the defense of selective enforcement. I'm sure you might have heard of that. Well, selective enforcement is not a cause of action. It's not, a lawsuit that the owner could bring against the association for selective enforcement. That's not how it works. Selective enforcement is a defense that is raised when the association tries to enforce a covenant or rule, right? And selective enforcement basically means, hey, you've enforced this, you failed to enforce this restriction or rule against Johnny. Now you're coming after me. This is selective enforcement, okay? And if properly raised in court, a judge could find that the association has selectively enforced a restriction and will not uphold the rule or covenant against Sally in that particular case. So you want to enforce uniformly. The other thing is you want to enforce in a timely fashion. So in Florida, when the board or its agents, which includes your management company, when you become aware or should have become aware of a violation, you have 1 year from the date the board or its agents knew or should have known of the violation to then bring formal legal action in court to enforce the violation. Okay. And if you don't enforce the violation timely within that 1 year period, then the owner, the resident, could raise a successful defense of waiver. And waiver essentially means, hey, board, you've known of this violation. Okay. You should have brought it within this time frame, within the year of the date you knew or should have known. But you sat too long in your hands, and now you have waived the ability to enforce this covenant or rule against me, okay? And again, if properly raised in that covenant enforcement lawsuit or action, then yeah, the association could lose. Now, if the board is in that position right now where there's been a number of covenants or rules that the board has not, or even past boards has not uniformly or timely enforced over the years, there is a process by which the board can essentially resurrect those covenants and rules. Okay, the process is called republication. Okay, it is a board action. It's done at a board meeting and essentially would require the board to then mail out some newsletter or some memorandum letting the owners know, hey, we've not enforced this particular restriction. Okay, but effective, whatever date in the future you choose going forward, we're going to start enforcing. So anybody that is currently in violation will have to be grandfathered in. Unfortunately, that is part of republication. You're going to have to grandfather existing violations, but that means that going forward, you'll be able to enforce the violations, the covenants against new violations. All right. And directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the association. So it is the board's fiduciary obligation or duty to act in the best interest of the association. That means you got to uniformly, timely, and consistently enforce covenants and rules. And if you don't do that, then yeah, you subject the board to potential claims of breach of fiduciary duty. So what are some of the specific covenants that you might find in your declaration that you are or should be enforcing? Well, I've listed here some of the more common. You can certainly have additional restrictions or covenants in your documents. You might have, for example, architectural standards. Okay, or covenants addressing alterations to the unit or to the parcel. It's difficult to enforce architectural changes to a unit or a parcel if you don't have standards or specifications in place, right? So if you don't have that now, something for the board to consider, right? Adopting specifications or standards for alteration. So, hey, owners, you can replace your roofs. However, your roof needs to meet these standards. It has to be this type of shingle, it has to be this color, and any other factor that the board deems relevant. And for condominiums, the same thing. If owners, for example, are responsible for maintaining their windows and units, and they have to replace it, well, you want to include or adopt specifications and standards as to the types of windows and doors that owners can install in order to maintain uniform appearance of the condominium. You might have an age restriction requirement. This will apply to those communities who qualify as housing for older persons, which means therefore 55 and older communities. Very important that you, if you have legal counsel, make sure that you are complying with legal requirements to maintain your exemption, right? Because if you don't, then it becomes difficult to enforce the age restriction. You might also have pet restrictions on leasing, sales, guest occupancy restrictions. You might have parking vehicle restrictions, and then nuisance conduct. Most declarations have some form of nuisance restriction. basically that an owner shall not conduct himself or herself on condominium property or an association property in a way that would create a nuisance to other residents. With all these covenant restrictions and rules and regulations, you want to make sure that you document every violation. Okay, and we'll talk about the different remedies and enforcement options, but it all starts with documenting the violation by the board or agent, which means your property manager. The reason you want to document is by the time you go to your legal counsel and instruct your counsel to send a demand letter on a particular violation, at least with our firm, the first thing I'm going to ask you is, okay, well, send me the backup that you have accumulated on this particular violation. And the backup, the documentation can include things like, internal reports. If owners have complained to the association of certain conduct or certain violation, perhaps you instruct the owner to put that complaint in writing, or maybe the owner emailed the complaint to manager. Okay, that constitutes backup. If the board has sent prior violation notices to the owner or the resident, that's part of the backup. If this is a violation or situation that perhaps required the association to get police involved, right? You call the police came, a police report was filed, get a copy of that police report. If you have, a security service, right? If part of their standard operating procedure is to document or create incident reports, right? Whenever an owner or resident complains, then that would also be part of the documented backup on the violation. So you want to basically collect all of this backup because eventually when you refer the issue to your attorney and the attorney then sends a demand letter and the violation is not resolved, right? And the board wants to then pursue further legal action to enforce the violation. Well, that is the backup that we're going to need to present in court in order to succeed, right? There are never guarantees in court, but the more backup you have, the higher the chance and likelihood of the association succeeding. All right. So we've talked about the type of covenants that you can enforce, how you should be enforcing. Let's talk about now enforcement remedies. So the first step in enforcement action typically is to mail the owner a notice of violation, right? Now, some communities, some associations have, some form of a violation policy, which outlines basically, these are the steps that we will follow when enforcing a violation. And maybe in that violation policy, the first step for you is to have management send a violation notice, right? If you don't have a violation policy, then, I encourage you to speak with legal counsel about developing one, because this will basically set up the framework, right? And then owners now will become aware that this is how violations will be enforced and what they will be subject to. Your policy might then include a second violation and then a final violation notice, or you might just have a first and a final before you turn over the violation to legal counsel, right? That's, business decision, how many violation notices you want to give to your owners and residents before you turn over the file to your legal counsel. But the notice must include a statement of the violation and should provide a deadline for compliance, allowing the violator to correct the deficiency. So I've seen some crazy notices of violation. So you want to keep it simple, right? Here's your violation. You want to cite to the specific section in your covenants or in the rules that the violator is violating, and then let them know what they need to do to correct it. And then give them a reasonable deadline, right? That is basically the gist of your violation notice. Now, I always recommend, and if we are to send a violation notice, we typically send the violation notice certified mail as well as regular mail to the unit and parcel address. But if the owner has provided an alternate address, and that is the address that you have in your official records, then send the notice, the violation notice, to that property address, as well as to the unit or the parcel address. Okay. And then if the violation involves an occupant, an additional occupant, or a tenant, and the owner is not in residence, well, again, the owner is responsible for the conduct of the tenant and the occupants of the property, right? And so you will want to definitely address the notice of violation to the owner, right? So, hey, owner, this occupant or this tenant of your property is doing XYZ. That is in violation of our declaration. Please ensure that your tenant or occupant does XYZ to remedy the violation by this deadline. Otherwise, we will have to consider other legal remedies to enforce the violation. And then you'll want to send a copy to the tenant or the occupant as well, right? But definitely to the owner. Okay. And then ultimately, if the owner doesn't comply, you can send the file over to legal counsel. But let's say you want to hold off on sending it to legal counsel. What other remedies do you have? Well, one option is fining. Let me just pull this here. All right. So one option is to fine. Now, the association has the authority to fine, and we'll talk about HOAs for a moment, pursuant to Section 720.305 of the Florida statute. You can fine the owner's tenant, guest, invitees for failure to comply with the governing documents or association rule. Now, you do not need to have authority to fine specifically set forth in your declaration or in your bylaws. The statute already gives you that authority. So if you look through your declaration or your bylaws and you don't see specific language saying you can fine, nothing to be concerned about. The statute gives you that authority. Now, for HOAs, the statute says that a fine may not exceed $100 per violation and may be levied on the basis of each day of continuing violation, but may not exceed $1,000 per violation in the aggregate unless otherwise provided in the governing documents. Okay, so that means that the maximum you can fine is $100 per violation. Every time that violation continues, so let's say we're talking about a pet violation, right? You already send the owner a letter saying they need to remove the pet by a certain date. Every day that that pet remains in the property is an extra up to $100 that you can fine, up to a maximum of $1,000 for that particular pet violation. Unless your declaration says and gives you authority to fine for more than $1,000. Now, typically, especially with the older documents, you might not have specific language in your declaration allowing you to fine for more than $1,000. So typically that would require an amendment to your declaration. So if you're interested in increasing your fining capacity, then consider an amendment to your declaration. And typically amendments do need to get approved by the membership. So I encourage you to get with your legal counsel to draft the language for this amendment and then to assist with presenting the amendment to the owners for approval. Okay. There we go. Now, a fine of $1,000 or more may become a lien against the parcel. So what the statute says is that a fine of less than $1,000 cannot become a lien unless your governing documents allow it. That means that if you have specific language in your declaration allowing you to fine for $1,000 or more, then what that means is that you can then collect the fine. If the owner doesn't pay that fine voluntarily, you can collect the fine as a lien against the parcel. So you would adopt it as a special assessment with 14-day notice to the violating owner. And then once you adopt it as a special assessment, and if the owner doesn't pay, then you can proceed through the collection process, which means you can then at some point file or record a claim of lien against the parcel to collect this fine. So for HOAs, fining could be a viable option, but again, you have to have specific authority, language in your declaration that says, yes, the association can fine for $1,000 or more. And if you don't, then consider an amendment. Now, the fine may not be levied unless the association first provided the violating party written notice of the violation and then an opportunity to attend a hearing on the alleged violation no sooner than 14 days from the date of the notice. So, just as a quick background, the fining process that's set out in the statute is really what I call a two-step process. So the first step is the board adopts the fine, but the fine cannot be imposed unless you have this committee ratify the fine. And the date of the committee hearing has to be no sooner than 14 days from the date that you send the notice to the owner of this hearing. So your notice must include a description of the alleged fine, the specific action that is required to cure the violation if applicable, and then the hearing date and location for the owner to appear at this hearing. Now, new law that went into effect July 1st of 2024 is that the hearing must be held within 90 days after the issuance of the notice of the hearing of the fine, right? So you have to give 14-day notice of that hearing, and then that hearing needs to actually take place 90 days from the date of that notice. Now, the hearing has to be held before a committee of at least 3 members appointed by the board who are not officers, directors, employees of the association, or the spouse, parent, child, sibling of an officer, director, or employee. So yes, I mean, I recognize that for some associations, this might be a problem to actually find committee members who are not any of these individuals. And if you are in a smaller association, yeah, this could be potentially problematic. So if you cannot get a committee of these impartial individuals, then perhaps fining is just not a viable option for your association, and then you would have to consider other options to enforce a violation. Now, if the committee does not approve the fine or the suspension, which we'll talk about momentarily, then the fine or suspension cannot be imposed. Now, the committee's role here is not to negotiate the fine, right? They're not there to see if the fine needs to be reduced or increased. No, their role is really, it's a yes or no vote. They're there to either confirm the fine that was adopted by the board or reject it. Now, within 7 days after the hearing, the committee must provide written notice to the parcel owner at his or her mailing or email address that is in the association records of the committee's findings, as well as any applicable fines that the committee approved or rejected. And then as well, you need to let them also know how the violation can be cured. So just because the fine was confirmed doesn't mean that, you know, the violation, the underlying violation doesn't need to be addressed. That still needs to be addressed. Now, these are some of the changes that went into effect July 1st of 2024 with regard to fines for HOAs. If a violation has been cured before the hearing or in the manner specified in the 14-day written notice or the committee's findings notice, then a fine may not be imposed. If a violation is not cured and the proposed fine levied by the board is approved by the committee, then the committee must set a date by which the fine must be paid, and that date must be at least 30 days after delivery of the committee's findings notice. And then attorney's fees and costs cannot be awarded against the parcel owner based on actions taken by the board before the date set for the fine to be paid. Okay, so if you got your legal counsel involved in this violation, those fees cannot be awarded based on actions taken by the board before the date that the fine was that the fine is to be paid. Now, if a violation and the proposed fine levied by the board is approved by the committee, and the violation is not cured or the fine is not paid, then reasonable attorney's fees and costs can be awarded to the association. However, attorney's fees and costs may not begin to accrue until after the date noticed for payment in the committee's finding notice and the time for the appeal has expired. Now, also, new law that went into effect July 1st of 2024. Regardless of anything that's provided in your governing documents, the association cannot levy a fine, and you cannot suspend use rights for any of the following: leaving garbage receptacles at the curb or end of the driveway within 24 hours before or after the designated garbage collection day, and also cannot levy a fine or impose a suspension for leaving holiday decorations or lights on a structure or other improvement on a parcel longer than indicated in the governing documents, unless such decorations or lights are left up for longer than a week after the association provides written notice to the violation to the parcel owner. All right, authority to fine for condominiums, very similar to HOAs. So condominium associations have the authority to fine pursuant to Chapter 718.303 of the Florida statute. So you don't need to have the authority in your governing documents. The same fining process, the two-step process with the board first adopting the fine and then the committee ratifying or rejecting the board's fine, same process applies. And the same dollar limitations apply to the condominiums as with HOA. So up to a maximum of $100 per violation with a maximum aggregate fine of $1,000. Okay. Now, the distinction with condominium associations is that a fine may not become a lien against the unit. It may, however, be used for suspension of use rights and disqualification of a director. So, unfortunately, the current state of the law for condominium associations is that regardless of what your documents provide, and even if your declaration gives you authority to collect a fine as a lien, the statute says you cannot do that. And so the statute will control in this particular case. Okay, so that means that if you've gone through the proper channels of imposing a fine, it's been confirmed by the committee, you've given the owner an opportunity to pay, and the owner hasn't paid, well, unfortunately, the fine will just, sit on the account ledger. Hopefully, when the unit is put on sale and you receive an estoppel certificate from the title company, then you will want to reflect that fine and any other assessments or any other fees and charges that the owner owes to the association. You want to reflect that on the estoppel so that those fees and charges get paid at closing. Okay, and that's the best you can do at this point, unless the statute changes. If the fine or suspension is approved by the committee, the fine is due 5 days after notice of the approved fine is provided to the unit owner. And then the association has to provide written notice of such fine by mail, hand delivery, and if applicable to any tenant, licensee, or invitee of the unit owner. All right, shifting gears, suspension of use rights. We just talked about fining. Another option for covenant enforcement is to suspend use rights and voting rights. So the associations, both HOAs and condominium associations, can suspend the rights of an owner, their occupants and tenants, to use portions of common areas or common elements, common facilities, as well as suspend voting rights if the owner is more than 90 days delinquent in any monetary obligation to the association. Okay, so we're going to talk about suspension of use and voting rights for delinquencies. So you have to be more than 90 days delinquent. If you're going to suspend use right and voting rights for delinquency, the delinquency has to, the suspension only needs to be approved by the board at a duly noticed board meeting. So you don't need the committee hearing to then ratify. This is just a board action. Now, the suspension does not apply to the portion of the common areas or elements used to provide access to the parcel or utility services, nor can it impair vehicular or pedestrian ingress to or egress from the parcel, including the right to park. So suspension of use rights really just applies to your common facilities, right? Such as the pool, the gym, your clubhouse, recreation area, and any other amenities that you might have in your community to which you can control access. Right, so if owners require a fob or some other key system to get into these facilities, and you have the ability to deactivate it if an owner is, is delinquent or in violation of covenants, which we'll talk about in the next few slides. Well, then, then this could be a viable option for you. If you don't have the ability to control access to these facilities, then again, this might not be a viable option for you for enforcement. For condominiums, suspension cannot include limited common elements intended to be used only by that unit. So that means you cannot suspend the right of an owner, for example, to use the balcony, if a balcony is considered a limited common element to the condominium. You also cannot suspend common elements needed to access the unit, utility services, parking spaces, or elevators. Okay, so essentially you cannot prevent an owner from going to or from their unit or parcel. Now, also for condominiums, it requires that the monetary obligation on which they're delinquent to the association be at least 1,000 or greater. Right? So you have to be delinquent for 90 days. The delinquency has to be at least 1,000 or more, and you have to provide the owner at least 30 days notice of the delinquency before you can suspend voting rights. And monetary obligation can include, for example, not only regular special assessments, it can include attorney's fees, costs, any interest, if you're authorized to collect interest and administrative late fees on any delinquent assessment, and would also include fines. So if the owner if you find the owner, they haven't paid the fine, then you can use the delinquency and the fine to suspend voting rights and use rights. Now, a new change to the law that took effect July 1st of 2024 is that at least 90 days before an election, an association must notify a unit owner or member that his or her voting rights may be suspended due to non-payment of a fee or other monetary obligation. Okay. Now, to take effect, written notice of the suspension has to be mailed or hand-delivered to the parcel owner or the unit owner. And then if voting rights are suspended, the voting interest allocated to the parcel or unit is not counted towards the total number of voting interests for any purpose, including the number necessary to establish a quorum. So what that means is, let's take the scenario where you're looking to amend your governing documents, right? We've talked about amending. And let's say you have a community of 100 parcels or 100 units. And let's say for this particular condominium, quorum is a majority of all the owners, which is 50% plus one of the 100. Okay. So if you suspended the voting rights of, let's say, 10 owners, 10 delinquent owners, well, now the quorum that you need to establish is going to be based on a majority of the 90, not a majority of the 100. And let's say you need the approval of 2/3 of the entire membership in order to get this amendment passed. Well, then if you suspend the voting rights of 10 units, then the vote that you need to obtain is going to be 2/3 based of 90, not 2/3 based of the 100. Okay, So you can see for some communities, suspension of voting rights is, you know, a viable remedy to at least get some amendments passed, or really could work on any issue that requires a membership vote. All right, and then we've talked about suspension of use rights for delinquency, as well as suspension of voting rights due to delinquency. You can also suspend use rights for violations of your covenants and rules in association. Let's see here. Now, you cannot suspend, if you're going to suspend use rights for covenant violations and rule violations, you cannot suspend use of portions of the common area used to provide access to the parcel, utility services, nor can it impair vehicular and pedestrian egress to and egress from the parcel, including the right to park. So very similar with the other suspension with suspension of use rights and voting rights for delinquency. Now, suspension for failure to comply with the governing documents cannot be imposed unless the violating party has had an opportunity to appear before the committee on the issue. Same procedures with the fining. So unlike with suspension of use rights for delinquencies, suspension of use rights for covenant and rule violations does require the two-step process. The board needs to first adopt the suspension, and then the committee needs to ratify or reject the suspension, right? With the 14-day notice of that hearing. All right, so we've talked about fining, we've talked about suspension of use rights and suspension of voting rights. But let's just say, you know what, none of these remedies are viable for our community. Okay, what other alternatives do you have? Well, at this point, provided that you have documented the violation and you followed your violation policy, your last resort would be to institute formal legal action, right? To force the owner to either comply by, you know, requiring them to do whatever they need to do to comply with the with your covenants and rules, or to force the owner to stop whatever conduct is that's creating the violation. Now, before you can file formal legal action in court, before you can file a lawsuit or complaint against the violating owner, you have to follow certain pre-suit procedures. Okay, so for HOA, there are certain types of disputes that are subject to pre-suit mediation. In other words, you have to do mediation, you have to go through mediation for these types of violations before you can file a lawsuit in court. And this is something that your legal counsel obviously would be more familiar with, but just so that you're generally familiar with the process, we'll talk about it here in the next few slides. So for HOAs, disputes subject to pre-suit mediation include use of or changes to the parcel or the common area. So for example, if an owner has undertaken an unauthorized alteration or an alteration of the parcel with that is not in conformance with the association standards, and you want to force the owner to correct that. So let's say the owner paints their house in purple, and that is not an authorized color, and you want to force the owner to paint the house either back to the original color or to one of the colors that's within your approved color wheel, and the owner just doesn't want to do it voluntarily, well, you'll have to go through pre-suit mediation before you can file a lawsuit in court on that particular issue. Amendments to the association documents. So if you amend the documents, let's say without proper membership approval, and any owner wants to legally challenge that amendment, that would have to go through pre-suit mediation. Issues or disputes regarding meetings of the board or committees appointed by the board, membership meetings, not including elections, access to official records, and covenant enforcement. Any of these issues have to go through pre-suit mediation. Disputes that are not subject to pre-suit mediation, which means the association can file a lawsuit in court immediately, following whatever violation policy you've adopted. Then they would include collection of an assessment, fine, or other financial obligation, including attorney's fees. So you don't need to go through pre-suit mediation to go through your collection and foreclosure. Any action to enforce a prior mediation settlement agreement, eviction or removal of a tenant or occupant from a parcel. So eviction is a specific cause of action, right? Is to remove a tenant. Typically, this will arise if you have an owner who's leasing a parcel to a tenant that is perhaps a nuisance tenant. Presuming you have the authority in your declaration to evict the tenant, and normally the association would not have that authority, and the reason is because the association is not the landlord, they don't own the property, and so they are not in privity of contract with the tenant, right? So if you don't have that privity of contract, you can't just evict a tenant. The remedy would be for the association to file a lawsuit against the owner to force the owner to remove the tenant. But if you have the authority to evict, which means the association would step in the shoes of the owner landlord, right, and then can directly file an eviction action against the tenant, well, you don't have to go through pre-suit mediation. Alleged breaches of fiduciary duty by one or more directors, any recall and election disputes, they're not subject to pre-suit mediation, and then any dispute between and among parcel owners or between parcel owners and tenants, unless the association is a party. Okay, so similarly with condominium associations, okay, before the association or an owner of a unit can file a lawsuit on a particular issue, well, you might need to go through pre-suit mediation. Okay. Now, it used to be that you had to go through the arbitration process, and we'll talk about the difference between arbitration and mediation. The statute was changed several years ago, which now provide that you don't have to go through arbitration. You can choose mediation. Okay. So disputes in the condominium setting that are subject to pre-suit mediation include the authority of the board under the law or association documents to either require an owner to take an action or refrain from taking action involving an owner's unit, as well as any alteration or addition to the common elements. And then the failure of the board to either properly conduct elections, give adequate notice of meetings, properly conduct a meeting, or allow inspection of books and records. Okay, have to go through pre-suit mediation. Disputes that are not subject to pre-suit mediation include title to a unit. And the way this would come up is, let's presume that in your community, the board is authorized to approve or disapprove sales and transfers of title. And let's say you have a particular owner that just took title to a unit without going through board approval, right? And then is refusing to get board approval. Well, it becomes more difficult to force the removal of an owner from the unit if they have title. Okay, so typically what you would have to do is essentially void title. It is a very costly process, and most boards choose not to go through it. But if you end up going through that process, well, you can pursue legal action to void that title without having to go through pre-suit mediation. Also, collection or levying of assessments, eviction, removal of tenant, alleged breaches of fiduciary duty, and then any claims for damages to a unit based upon the alleged failure of the association to maintain common elements or condominium property. Those do not have to be mediated. Okay, let me just see what time. All right, so we're almost coming up in the hour. So the next few slides really talk about just generally outline what the mediation and arbitration processes are. For condominiums, additional disputes that are not subject to pre-suit mediation, they include recall and election disputes, as well as disputes between and among parcel owners, and between unit owner and tenants, unless the association is involved. Effective July 1st of 2027, the term dispute now will also include the failure to obtain the milestone inspection, failure to obtain structural integrity reserve study for those who are required, the failure to fund reserves, and the failure to make or provide necessary maintenance or repairs to the condominium property recommended by a milestone or the CEUs. These disputes are not subject to mandatory non-binding arbitration. Rather, they have to be submitted to pre-suit mediation. And if unresolved, then litigation. So with pre-suit mediation, mediation is essentially the process by which there is a neutral third party that is selected between the association and the violating owner. And the role of this third party is really get the association and the owner to come to an agreement, to a resolution of the dispute. And if anyone has ever participated in a mediation, typically after opening statements, each party goes to a separate room, and then the mediator kind of floats between the two rooms, trying to, get the other party to come to an agreement, okay? And if the parties come to an agreement, then typically a mediation settlement agreement is executed, and then it becomes effectively binding, right? Then the parties have to comply. And if they don't comply, then either party can pursue a lawsuit in court to enforce this settlement agreement. So typically your legal counsel will send a letter to the violating owner, which lists 5 acceptable mediators and provides 20 days to respond. And then if the owner does not respond within a certain time frame, then essentially the association can proceed with a lawsuit without having to go through mediation. And then arbitration, if you choose arbitration, although that's not our recommendation, it's a little bit different. Unlike with mediation, with arbitration, you have a third party, neutral part. You have a third neutral party called an arbitrator, but that arbitrator acts more like a judge. So it's almost like an informal, court proceeding where the arbitrator is a judge, both parties present evidence, and then the arbitrator eventually makes a ruling. Okay. And then there's a filing fee that you'd have to file with the division. Typically that's, the owner files the complaint. And then at any point, if you selected arbitration, you can still select a mediation. Okay. And then as a prevailing party in the arbitration, the association would be entitled to recover their attorney's fees. With mediation, both parties pay for the mediator, and then each party is responsible for their own attorney's fees. Okay.